The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three interesting cases. I'm honored to be here with my friend Judge Richardson and my friend Judge Floyd. Our first case is Ibarra versus Garland, an immigration case. And is that Ms. Thwaites?
Thwaites, Your Honor.
Thwaites, Ms. Thwaites? I'm sorry for mispronouncing your name.
That's quite all right.
It's great to have you with us.
Thank you. Good morning. May it please the court. Whitney Thwaites on behalf of the petitioner. The issues for review in our contentions are as follows. 1, the Board of Immigration Appeals, or the BIA, erred in finding that the petitioner failed to establish good moral character. And 2, the BIA erred in finding that the petitioner's due process rights were not violated after counsel invoked the petitioner's Fifth Amendment rights against self-incrimination.
Ma'am, before you go too far, what is the standard of review? Because I don't think the government's taking a position. What's your position?
Your Honor, I believe the standard of review, I know that the Wilkinson case, and I'll get into that in my argument, does not establish a standard of review.
Right.
I believe it's abuse of discretion.
On which issue?
As to both.
As to both issues, everything's abuse of discretion.
That's what we contend, yes.
So can I ask you about that just a little bit? So Wilkinson says that it's a discretionary review, or deferential review is the word it uses.
Yes, Your Honor.
And I'm not sure any of this matters, but there are like a handful of options for what deferential review might look like. But we don't generally apply abuse of discretion, whatever that means, to agency action. We tend to review that either as arbitrary and capricious or for substantial evidence, which maybe is the same thing as abuse of discretion. I'm not saying that there's
Right.
like a whole hill of beans difference here among these options.
Well-
But help me understand why you use the term abuse of discretion, and do you think it matters as compared to calling it, is the decision supported by substantial evidence, or is it arbitrary and capricious?
Well, Your Honor, I believe the reason that I would say that it's an abuse of discretion standard is a lot to have to do with what's the transcript on the record on appeal. We believe the judge abused his discretion and the way he conducted the hearing. The substantial evidence standard.
We don't review legal issues for abuse of discretion. If there's any legal issues here, it's got to be de novo, doesn't it?
Well, then, I mean, yes, I can understand that.
The law's the law.
Right.
I mean, an IJ doesn't have authority, or we don't have authority to
Yeah.
discretionarily decide what it is.
Yes, I would concede that, Your Honor.
But the point of Wilkinson, the Supreme Court's decision in Wilkinson, is that when we have a set legal standard, which we have here.
Correct.
And we have set facts, because we can't review what the facts are. The application of the facts to a set legal standard is what they refer to as a mixed question of law and fact, and we review that with deference.
Yes, and I will
The
get to
question is,
that.
what does deference mean, right? And not, I guess, I'm just not aware of any instance in which a court reviewed an agency for abuse of discretion. It's sort of
And- I
inconsistent
mean-
with the manner in which we review agency action, right? We do that for courts because we directly supervise courts. We don't supervise, in any technical sense, agencies, right? We review whether their actions are lawful, but there's a distinction there, right?
Yes, and I do think that the Wilkinson case does state that it is a deferential standard, but the question is, what does that mean? I think that there is, an argument that they do have to give deference to the court, but how much deference are we looking at? And that's how I took it. It would be wonderful to have a de
But
novo
normally
review.
in a ruling like that, the Fifth Amendment issue here,
Yes, Your Honor.
it's the middle of a trial, a trial judge would get some discretion in making that kind of a ruling, perhaps. Would that be different in an IJ situation?
If the trial judge had deference to, I
To
believe,
decide,
the constitutional issue,
well, it does, it's the invocation of the Fifth Amendment.
right. I believe that in this situation, again, our argument is that the judge abused his
I
discretion
mean,
and
all
denied
he
the
was
due
saying,
process.
I don't, he was saying, the defendant here, the petitioner has to assert it himself,
Yes, Your Honor.
not the lawyer.
Yes, and I understand that, and that's actually my second argument
I know, but
on
that
appeal
might
is,
be a-
is the,
But you said that this abuse of discretion thing applied to both
right, well,
issues, and maybe you have to consider them separately.
I'm sorry I asked that question.
that's okay. I believe, so my Fifth Amendment argument, there is case law on point. There's the Garcia-Quintero case, which is the Ninth Circuit Court of Appeals decision. And it doesn't say that counsel can assert the privilege for him, for the petitioner, but it does say that counsel can consult with the petitioner as to his Fifth Amendment rights. And I believe by the nature of immigration proceedings.
You mean at a time the witness, the petitioner is on the witness stand,
That's correct.
then he can consult with his lawyer?
Yes, if the lawyer,
And is that a,
that's what happened in the Garcia
is
case.
that a mandate that's inflexible, or is that a discretionary call by the judge?
I would contend that it's, I'm going to say that it's not mandated. However, the nature of immigration proceedings are such where there's a substantial language barrier and often a misunderstanding of the legal proceedings in the United States, that in this situation, it calls for counsel to be able to consult,
Did counsel
especially upon
ask-
objection.
Did counsel ask to consult?
Counsel did not have the opportunity to ask to consult. This,
Well, if
on
he-
the record.
If counsel objected, then counsel could say also, well, I'd like to talk to my lawyer. It's not like he wasn't like gagged, right?
No, Your Honor.
Right? I mean, when you say he didn't have an opportunity to ask to speak to his client, like that doesn't seem right. And the client didn't ask to speak to him. I mean, I'm not sure what the answer is. If he had asked and the judge had said no, that would seem like a tough discretionary call.
I
Where he
believe-
doesn't ask and the client doesn't ask.
I believe what happened in this case, and if I'll refer to the transcript, the judge was actually taking over on the direct and asking the questions. Mr. Devine objected.
Which we've said an IJ is supposed to do. An IJ has an obligation to develop the record.
That's correct. But typically, the way that it goes in immigration hearings is the counsel for the respondent gives direct examination, then opposing counsel crosses, and then the judge asks questions. The way this hearing went is the judge.
was asking questions, and the witness took the fifth?
The witness did not take the fifth in this case because counsel objected and said, I cannot allow my
Counsel
client.
objected,
Yes.
and counsel says he wants to take the fifth,
He says, I cannot allow my client to incriminate himself.
which is pretty much
Taking the-
invoking the fifth,
Yes, sir.
fairly construed perhaps.
And the client chose not to follow that advice.
The client, yes, that's what happened in this case. The client just
There's a,
continued, but I don't think that the counsel was not given an opportunity to consult and explain it. And again, there's often a misunderstanding of the procedure, in the United States in immigration cases. Also, counsel didn't
There's also a
anticipate.
misunderstanding in like almost all proceedings, right? We understand that, but that's why we have lawyers there, right? So if he thinks that he needs to speak to his client, if he thinks there's a problem, it's his job to say that.
And he did object on multiple occasions. He continued to object to the line of questioning. And I believe, he was giving deference to the judge because the judge was actually doing the questioning for the most part. on these
I got another
issues.
question in that context, and maybe it's more appropriate for your colleague there when he gets up there. But the Justice Department's got some, in this, got a policy, or they used to have, that permitted lawyers to invoke the Fifth Amendment for targets or subjects of investigations by writing a letter to the U.S. Attorney and say that my client will, or whatever the letter would say. Would that kind of, I don't know whether it still exists or not, but if it exists, would that apply to immigration proceedings? They're part of the Justice Department.
I believe so, Your Honor. I believe in this situation, it wasn't anticipated that
Do the
pending.
DOJ policies apply to the immigration judges?
Yes, sir.
I don't
And
know
I
what the
believe some of
policy
those,
is. Do you know what the policy is now?
on the,
Whether a lawyer who can say, I represent this person, and he invokes the Fifth Amendment.
I believe the current case law,
And the lawyer signs it as counsel for him and submits it to the United States Attorney or the lawyer for the government. Is that sufficient to get him out of a subpoena, for example? Or to keep him from answering questions or going any further?
I honestly, the case law doesn't distinguish on that issue. So I honestly don't know if that would have worked in this situation.
But the case law actually says that you can only invoke the Fifth Amendment question by question,
Yes,
right? You can't, and the Department of Justice, I think it's totally fair, often sort of, as a matter of grace, you might say, sort of accepts a lawyer and says, okay, we won't put you in the grand jury if you're just going to invoke. But to actually invoke the Fifth Amendment, you can't even do it as a blanket matter. You have to do it question by question.
that's correct, Your Honor.
So if
And
you're in a hearing, whether that's a grand jury hearing or a court hearing, in order to invoke the Fifth Amendment, the witness has to say that particular question would incriminate me. And then the judge can make a judgment if somebody objects to that, but it's on a question-by-question basis. That's what we've said has to be done.
yes, and I understand that, Your Honor. Mr. Devine did object to an entire line of questioning. He said, I object to this entire line of questioning, and I believe that satisfies the question by question. But in this situation, the judge said, I will indulge, and then they continued to allow the testimony, which these were pending charges, and this could have had dire consequences for Mr. Ibarra in criminal court, and Mr. Devine was representing him as to those issues in criminal court. So he was both the criminal attorney and the immigration attorney. I believe I only have a few moments left.
In a criminal trial, I mean, we often do in a criminal trial where when it's time to testify or not, right, which is effectively in a criminal case to invoke the Fifth Amendment or not, don't we require the district court judge to get an answer from the defendant himself? We won't take the lawyer's word on it?
Yes, and that is generally, that's the practice, but we contend that
Is that what the law is?
that's what the Couch case says. That's what yes.
What's that?
It's a
Is that
Supreme Court.
Supreme Court?
It's a U.S. Supreme Court case.
And it's an individual
But it's a
right.
tax, it's a
Yeah,
tax case, and it's
I
about
believe the
document
law.
productions.
I'd accept the representation of the lawyer. I believe lawyers.
And that's
They're
what we,
officers of the court.
that's what we believe as well, Your Honor, and
And
that's,
that's my view, that
Ye-
lawyers are officers of the court, and they're going to tell the court the truth.
yes, and particularly in this case where Mr. Devine was representing the petitioner in immigration proceedings and in the criminal proceedings. And he continued to object. So, therefore, we contend in this situation, just like in the Garcia case, where the judge in that case recognized the potential pitfalls in an immigration case when counsel's not allowed to consult with the client or assert a privilege for him, then,
Have we also done this in the context of like Miranda, right? That a lawyer can't invoke the right to remain silent? Which is like, it's a slightly different question, although not, we're in the same ballpark, that we've said a lawyer cannot invoke for a client.
Well, I think oftentimes in those situations with Miranda, I mean, the police officers are, the lawyer's not present at that point when they're having to read their Miranda rights. In this case, this is a trial, so, you know, the lawyer's
I understand,
there.
but
and-
it does come up sometimes where there's an investigation where a client is represented, the client is picked up, and the lawyer calls and tries to assert his client's Fifth Amendment rights. And we've, I think, said that you can't do that, right? That the lawyer can't invoke under Miranda the right to remain silent for the client, because it's the client's own right.
That's correct, but I
But
agree with
what I'm
Judge
talking
King.
about is the policy of the Department of Justice is that the lawyer can invoke.
Yes, and I agree with Judge
And
King
the-
on this.
And the immigration judges being part of the Department of Justice, do those things apply? And I'm talking about at least targets, subjects of grand jury investigations are not supposed to be taken into the grand jury if the lawyer says, my client is going to take the fifth, or if he takes the fifth, the lawyer signs it, they're supposed to accept it. That's the way it used to be, and I've never heard of it being changed.
I don't believe it has, Your Honor, and I believe that same situation would apply in this setting in an immigration proceeding. And I see that my time has expired, so I thank you. That concludes our argument at this point. I'll be back for rebuttal. Thank you.
You've saved some time. Mr. Tennyson?
Good morning. May it please the court. I think I'll start right off by saying I'm not aware of I hadn't thought about the policy, but from the way you describe it, it has to do with grand jury proceedings and whether or not someone will testify in grand jury proceedings and whether or
Maybe
not.
it's limited to grand jury proceedings
Do you know if it, does it include like
and
witnesses?
trials.
I don't know anything about the policy, but I was just going off of what you said, that it applied to grand jury proceedings. But let's assume that it is supposedly broader,
Do you
right?
I mean, I don't want to ask you questions of this, do you do any criminal work? You just do?
No, I don't do any criminal work. It's just purely immigration work.
ask.
So I've never looked, so
Okay.
I've never seen this before. I've not come across it. But there's a difficulty if that were the case, because if you could,
No, but everybody's working for the Justice Department.
everybody's working for the
That's what
Justice
it's-
Department. So, and we have a lot of policies, maybe not seen them all. But the thing is.
And I'm telling you, that's been the policy for 40 or 50 years,
Right,
unless it's changed.
right. And has this
It
been,
may not have been for the entirety of 50 years.
right, well,
I'm more familiar with the recent vintage and not sure about that policy.
Well, I was in the U.S. Attorney's Office more than 50 years ago.
right, okay. Did it apply
That's the way
to,
we operated.
the way you operated, it applied to people who were going into
And I
grand jury?
understood that was the Department of Justice policy.
Right. Oh, interesting. So let me look into it. I can definitely
And
see
I'm
what
not
that's.
saying it has anything to do with this. I think trial judges have a lot of discretion, too.
Right. They,
But then, that's maybe what's the standard of review?
right. Okay. So, but they do have a lot of discretion. And if you look at the instances in which the petitioner actually says something about the criminal charge having to do with his title, in the first instance, it's invoked. Well, in the first instance invoked by his attorney, the immigration judge responds by being kind of careful and asks, well, what are the charges? That doesn't have anything to do with what he did, it has to do with the charges, and he answers. And then the immigration judge follows up with, was that your car? And he says yes, and then he moves on. The second instance in which it comes up, again, the attorney, when the lawyer for the government, for Department of Homeland Security, asks about the mortgage or his mortgage or obtaining a driver's license. And again, he invokes the privilege, and the immigration judge allows it in discretion because those aren't questions that have to do with, those are questions that have to do with the prior criminal proceeding against him in federal court, and aren't related to the title charge.
In a civil proceeding like this, were he to have invoked the Fifth Amendment and refused to answer the questions, could the IJ draw a negative inference from that?
Oh, yes, Your Honor.
And so, a reasonable client here might say, what really matters to me most is the immigration issue. It's not this, criminal charge.
That is correct. And if that's the case, I mean, on the third time he's asked, and he's not asked about the charge, he's asked, how did you end up getting detained in the first place? And he says, oh, well, I was stopped, and because I had the fraudulent title and registration in my car. And the immigration, his counsel doesn't say anything. He doesn't offer the Fifth Amendment, he doesn't invoke the Fifth Amendment right.
Did either the witness or the lawyer ever ask for the right or an opportunity to consult?
No. Your Honor, he never did.
We don't know what the judge would have said at that point.
We have no idea what the judge would have said at that point.
Maybe it's an ineffective assistance claim.
Perhaps. But we'll leave that to a motion to reopen by him before the BIA. So moving on from the Fifth Amendment issue, back to whether or not the agency erred in finding that he lacked good moral character. Again, the standard of review, the government's position is that it's substantial evidence.
Why not? Can you help me understand why it's not abuse of discretion?
Right. I mean, and we had originally argued that it was discretionary because it seemed to have all of the multifactored approach that cancellation of removal did. I mean, that hardship did in cancellation of removal, right? You look at the activities that the individual is engaged in over the prior 10 years, the positive and negative equity, positive and negative aspects of their character, where they've engaged in any crimes, and then you sum it up to determine whether or not you have, good moral character or a lack thereof. And while that looked discretionary to us pre-Wilkinson, post-Wilkinson, that same sort of multi-factor analysis that you have for exceptional, extremely unusual hardship was found to be, a legal question, a mixed question of law and fact. And once we move into that territory, especially considering that, as the court noted in Wilkinson, the prior standard was given more to the discretion of the agency. The subsequent standard with exceptional, extremely unusual hardship seemed more clearly the application of legal standard. Whereas with good moral character, it's always been sort of a flat standard, even dating back to pre-INA days. And so for the same reasons that we would say exceptional and extremely unusual hardship is the sort of legal question, even if it is multifactored and extremely factual in nature, that the exceptional and usually unusual hardship standard would be reviewed for an abuse of discretion. We think that that good moral character should be reviewed, or under the catch-all provision, good moral character should be reviewed the same way.
And wait, you just said as abuse of discretion? You meant
substantial evidence, not abuse of discretion. Right. Although, if this court goes with abuse of discretion, we're perfectly fine with that. We think the two are very similar.
Again, what's your position? What's the Justice Department's position?
Substantial evidence review.
Substantial evidence.
That is correct.
But you just said,
right.
Like you didn't care.
Oh, no, the thing is that we would prefer substantial evidence.
You prefer substantial.
We would prefer substantial evidence.
But you don't, that's not your hard and fast position.
That's not a hard and fast, no. As long as we get deferential standard.
I mean, I guess maybe why you're saying you don't care is back to the sort of principle of like, is there a meaningful difference?
I mean, the thing is that irrationality one would assume that irrationality under the abuse of discretion standard, that the immigration judge act irrational or contrary to law, is very similar. If you're going to have an immigration judge acting irrationally and reviewing the evidence, that by the same token, any reasonable fact finder would look at that evidence and find that, that they would be compelled to find a different result. We think that there's not really much daylight between the two. But applying substantial evidence to this case, I mean, the petitioner in this case maintained a scheme, under which he assumed a fraudulent identity of another individual, a citizen, for a period of 5 years, 2 of them within the 10-year good moral character period. And a reasonable fact finder would not be compelled to conclude that given that, that fraud, that a petitioner, possessed good moral character. If this court has no further questions about this, the government will rest.
Well, I don't quite understand how, based, based on what you've said, where's the bad moral character in this case? I mean, all you say he didn't have good moral character. Well, why?
Why does he have
Yeah,
poor moral character?
you haven't told me a thing.
The reason why is because he used someone else's identity to engage in a scheme of fraud for 5 years to obtain not only a Social Security card, but a driver's license, a mortgage, homeowner's insurance, tags and title to a car. All of these things he did by adopting another person's identity, fraudulently so, the identity of a citizen. And he got criminally convicted, although not of that charge, but that brought him to the attention of
Well,
the...
actually, the charges were dismissed. The charges were dismissed.
Well, the charges were pled down. With the federal charge, he ended up...
No, illegal entry is not a lesser included of what he was charged. Illegal entry was not a lesser included of what he was charged.
Right. He pled to a different charge, but if you look at the actual criminal charge they pled to with the tags and title are in the record. It's not in this, let me see if I've got it here. If you look at, it's at the back here. He eventually offers the criminal records that come after his proceedings. And in those proceedings, he pleads down to a lesser charge on the fraudulent title. But beyond that, if you look at the final paragraph of 1101F, where there's the catch-all provision, behind the sort of statement that says, just because we have these now 8 other things listed here, that doesn't preclude another finding that an individual lacks good moral character. And then there's a but. And the but provision, there's this long sentence that says, but if you've got an individual who was a child at the time, and who made a false statement of citizenship, or a false statement, regarding the same, but both of that person's parents were citizens, and he did so under the, reasonably believing that he was a citizen, then that's not an instance of bad moral character. But the implication of that is that for someone who's an adult who makes that kind of a statement about their being a citizen, who did not have any reasonable basis to believe that they were a citizen, that it's perfectly fair game for an immigration judge to conclude that that fraudulent assertion of citizenship is an example of bad moral character. For that reason, this court should find that the immigration judge did not, that no reasonable finder of fact would be compelled to find that this petitioner displayed good moral character. Or to put it differently, substantial evidence supports the determination that the petitioner in this case lacked good moral character.
Now, were you saying then that the standard review on the first issue is substantial evidence,
Substantial evidence.
and on this Fifth Amendment issue, it's abuse of discretion?
I think considering that it's, I believe that since petitioner is arguing for a legal standard, and that is the application of some standard that counsel for a petitioner in immigration proceedings should be able to consult with their client while on the stand, and that the failure to allow him to do so is a Fifth Amendment violation. That sounds like a legal question to me, and that would be reviewed de
Well,
novo.
she said they didn't ask to consult.
He never asked to consult, it was waived. Right. And that was up to the discretion of the immigration judge as to how to conduct proceedings.
So you're saying it's an abuse of discretion?
So I would say as to what he did and how the
I'm
immigration
just trying
judge
to get the
interpreted it
government
would be,
position straight here.
right,
In case we agree with it,
right.
then you all are going to be stuck with it. The government is. That's going to be the standard of review.
So if
In
it
the
goes,
next case, and the case after that, and all that.
right, I think that insofar as this can be divided up and their argument can be divided
You
up,
need to check this out with the Solicitor General or anything,
I think
or the head
that,
of the department?
right, I think that our review is that this is a de novo constitutional issue broadly, right? And if it's a constitutional legal issue, to the extent that we're talking about, it's within the compass of that, that's de novo. If it's just a pure question of,
The question is the law or de novo?
Right, exactly. Questions of law are de novo, and constitutional questions are de novo.
Right.
And insofar as they're trying to parcel out some particular constitutional right with regard to consultation, that is a de novo question. If we're just asking about,
But
did the
sufficiency
petitioner
of
waive
evidence
this?
is-
That's also, I believe that the waiver issue is something this court can resolve de novo as well. But if it's a question about how the immigration judge conducts proceedings broadly, and it doesn't, and we no longer have,
Well, but their claim is just under the Fifth Amendment.
It's just under the Fifth Amendment.
The Fifth Amendment doesn't require the district court, or excuse me, the immigration judge to run his proceedings in any given way.
right,
If he runs his proceedings in a way that violates the Fifth Amendment, well, that's a Fifth Amendment problem.
right, exactly.
And
And
we
that's
don't take up
purely
a
constitutional.
constitutional question if we can avoid it.
That is true. And this court can avoid it by just saying that the
What's the
petitioner
case-
waived it.
What's the case that deals with avoiding constitutional questions?
Oh, right. So, gosh, I can't remember. But there are a few. There are some, not Zavidas. There are a series of subsequent.
Ashwander's the one you're looking for.
Thank you.
It's Judge King's favorite case, which is why I mentioned it.
All right.
But, and we hardly ever find any lawyers that recognize it.
Oh, okay. I should,
You'd be the real exception if you said.
if I had said,
I know all about Ashwander, 1936 case, some Supreme Court judge.
got it.
But that's the constitutional avoidance doctrine.
Right. I know,
Decide constitutional questions except as a last resort,
very good.
basically.
Right. I know there are some recent decisions on that, particularly in the detention
So if it's
context.
an
but-
evidentiary question, we review it for abuse of discretion.
Use it for- yes,
That's
right, Your
what
Honor.
judges do.
Right.
The judges get some discretion in ruling on evidence.
Right. And I think
Do
that
we
insofar
review
as,
abuse of discretion, do we do that? I mean, I haven't like run this down, but we don't typically review agencies for abuse of discretion.
I think, well, okay,
I
it
mean, if
depends
it's
upon the
fully
circumstance.
submitted to their discretion, right, we don't
Right.
have jurisdiction to review.
You don't have
it,
jurisdiction over it, right?
Right, and so it's odd to talk about that. We talk about something being arbitrary or capricious,
Right.
right? We talk about substantial evidence. Are there examples where we like correctly apply quote-unquote abuse of discretion as the standard of review to an agency?
Right, I'm not going to commit myself, but I wouldn't be surprised if this court applies abuse of discretion to denials of motions to reopen and motions for reconsideration, because those are both ultimately discretionary determinations. But they're not ones that are taken
Which
out.
ones do you think? I'm not
But
not sure that's true, but I'll look at that. Motion to
Right.
reopen and what's the
and
other?
motions for reconsideration, or denials of a continuance in the
Refer to
coast of.
this hearing as a trial, but a judge at a trial gets reviewed for abuse of discretion.
Right,
Maybe we're not reviewing them, the BIA's had to review them first.
right.
We're-
BIA reviews first, but they review either for purely factual questions for clear error and everything else de novo. So essentially, it's a flow-through. But the denial of a continuance is something else this court can review. So, various aspects of the procedure of immigration procedures have been reviewed by this court before. I can go and find out whether those are reviewed for abuse of discretion or not. I would be surprised if they aren't, especially considering that they're outside of the statutory bar for discretionary matters over which this court lacks jurisdiction. But if this court doesn't have any further questions, the government will rest.
Absolutely, right. Thanks very much.
Thank you.
Mr. Tennyson. Ms. Slates?
Thank you, Your Honor. A few things. I want to start off by saying that the initial issue in this case was a jurisdiction question, and I think that we've established that this court has jurisdiction under Wilkinson to review the good moral character analysis. I don't believe the government even argued that they don't. They do in their brief, but he didn't argue today that there is no jurisdiction. So I do believe under the code that jurisdiction's restored in this case, and this court does have jurisdiction to review. Also, As to the standard of review, there's no case law on point to support a substantial evidence standard of review. So we disagree that that should be the standard of review. That's the highest discretionary form. There's no case law saying that that should be the standard.
Why is that, why is that different in your mind? I guess I'm not totally certain it's different. We tend to review these questions for substantial evidence, right, in all the other immigration contexts. Maybe these motions to reopen are different. Maybe they are abuse of discretion. I'm just not certain about that. But that's like a particular discretionary decision. When we're trying to figure out, like, is there evidence that supports a legal conclusion in the
Correct.
immigration context? Every example I can think, which is the question we have here, right? Is there evidence to support the conclusion that you failed to show moral character? That seems to me to be a substantial evidence question.
I think that the reason that I'm arguing that it's not is that is the highest standard. But if the court is going to review it under substantial evidence, I do want to get to some of the facts of the case. I believe Judge Floyd pointed out that the petitioner did not plead to anything to do with the Social Security fraud. That charge was completely dismissed by the U.S. Attorney's Office. He pled to unlawful entry, which is a charge that virtually everybody in removal proceedings is charged with. And that was the charge. It was
Does
not.
finding good moral character require a conviction? Imagine he's not convicted of anything. Can the IJ determine that someone who has not been convicted of a crime lacks good moral character?
Well, the 10 factors.
Can you answer that question, yes?
Yes. There are 10 factors under Section 1101F that go through the factors, and those are not all criminal related. Habitual drunkenness and things of that nature are on that level. But I do think it's important that that charge was dismissed. And he did plead guilty to a misdemeanor charge, which is a very low-level charge. And he was in this country he's been in this country for 25 years at this point. This was a 5-year period of his life. Raul Cabrera was a friend of his.
Are you saying that you can't have bad moral character through a misdemeanor conviction?
I think
that could be evidence of
it depends, Your Honor. I think that in this
That could be
situation.
evidence of it, too. I mean, it's the conduct.
Correct. In this situation, it was a friend of his that allowed him to use his ID.
Going around using a false name,
Yeah, the reason
pretty bad stuff.
he got a false driver's license and mortgage. His wife is very sick. She has pulmonary hypertension, and so this was to be able to drive her to the hospital, to relocate.
Every fraud begins with like good motives, right? I mean, and I'm not saying that, I mean, I think an IJ could have reasonably found here that your client has good moral character. But an IJ could also reasonably find that he does not, right? I mean, that's the challenge I've got. I understand you have arguments, right, to say, don't think about this fraud as being as bad as it looks. All right, you might be right about that, but it's hard for me to see whatever the standard is that an IJ was required to conclude that a guy who not only used a false ID, but then used it to defraud, 2 banks, is the person that must be found to have good moral character.
I think that in this situation, the petitioner did go get his own driver's license, his own social security number, and I think that people have the ability to rehabilitate themselves. He made a mistake, and I don't think that that's dispositive of him being of bad moral character. And ultimately, as I bring this argument to a close, I think that if the court reviews the transcript in this case, it will become obvious that from the beginning of the hearing, the immigration judge did not carefully consider the factors in this case and showed bias in the rulings that he made. And for these reasons and the reasons discussed throughout the course of my argument, I respectfully ask this court to vacate the ruling of the lower court, or in the alternative, to remand to the lower court for a new ruling based on this decision, the statutory and applicable case law. Thank you, Your Honors.
Thank you very much. We appreciate your work. And
I can go down.
you want to go down?
No, I can go.
Okay. We'll come down and greet counsel, and then we'll go to the next case.
Oh, we go this way.
Our second case today is number 232176, Julie Sue versus Medical Staffing of America. And now, Mr. Pafford?
Yes, Your Honor.
You're on here as the first speaker, number one speaker. Good to have you with us.
Thank you, Your Honor. Good to be here. Good morning, Your Honors. Abram Pafford on behalf of Appellants Medical Staffing of America, DBA Steadfast Medical, and Lisa Pitts. May it please the Court, this appeal is a worker classification dispute arising under the Fair Labor Standards Act involving more than 1,100 skilled nurses working at dozens of medical facilities spread across multiple states across a 7-year period. The economic reality for these nurses is that they were free agents who on a rolling basis looked to maximize their weekly, monthly, or quarterly income across a wide range of steadfast and non-steadfast nursing opportunities. The nurses invested in their own training, licensing, and equipment, and they routinely exercised proactive control over the threshold economic decision of whether to work at all during a given pay period, and also, if so, for where and for whom and under what conditions. That autonomy naturally brought with it opportunities for profit and loss depending on their managerial skill in relation to their income-generating activities. And when the nurses did choose to provide medical care on shifts made available through the Steadfast Registry, they exercised almost total control over the manner in which their work was performed, in part because Steadfast possessed none of the medical supervisory infrastructure that's present in the key non-Fourth Circuit cases relied upon by the government and absent here. And on that record, we believe that the nurses who chose to pursue and accept shifts through Steadfast did so as part of a lawful independent contracting arrangement and not an employer-employee relationship. We have outlined in our briefs the basis for believing that the district court erred in reaching a contrary conclusion, and this case, as the court knows, is governed by a 6-factor totality of the circumstances test. But I think it's important to keep in mind, as this court has emphasized in McFeely and in the other classification decisions, that ultimately the test is driving at an underlying question of whether the nurses are, on the one hand, economically dependent on the particular defendant who is alleged to have been their employer, or on the other hand, are they, as a matter of practical economic reality, in business for themselves? And we think if the court keeps that prism or that framework in mind, which I think was described in McFeely as the touchstone of the 6-factor analysis, that it will conclude, for the reasons we've outlined in our briefs, that these nurses were fundamentally free agents in business for themselves.
At the end of the year, what were they given, a W-2 or a 1099?
These nurses were all given a 1099, and that is a truthful representation based on what I know. I'm not 100% sure what the record shows about that, but I know that they were given 1099s. And if we needed to supplement the record to demonstrate that to the court, we would, but they were certainly given 1099s. And in fact, the one place the record does reflect it is when we talk about the damages issue, which I frankly don't think the court will need to reach here. But we make the point in the briefs when arguing about some of the back pay table that Steadfast did have W-2 workers. It had about 15 W-2 employees who were in the office as schedulers and sort of administrative type folks, and they were paid on a W-2 basis, which is one of the reasons why we complained at the district court, once our firm got involved, that handful of W-2 workers had been improperly included in the back pay table because they were paid as W-2 workers and got overtime all along. But the nurses were all given 1099s at the end of every year.
Which would be an indication that you all thought they were independent contractors.
That is correct, Your Honor. Your Honors, may I?
But the government, as the Department of Labor, brought this lawsuit taking a different position.
That's correct, Your Honor.
That they're not independent contractors, they're employees. And the IRS probably watching this suit.
They may be.
1099s are appropriate.
We have not yet heard from the IRS, Your Honor, but depending on the outcome here, I imagine there could be engagement of that sort. But again, we think.
Do they have to, they once in a while take issue with the way tax returns are filed.
Yeah, that could be true. And again, there's never been any allegation of tax non-compliance in relation to our client. It was all 1099s.
Was that introduced in evidence? Was that at the trial? I mean, you had a 7-day trial, as I recall.
I think, I'm not sure that, I know that the trial court understood, and there was certainly evidence introduced through testimony that there were a handful of employees in the Steadfast office who were W-2s and the others were responsible for withholding their own taxes. I don't think they actually introduced necessarily all of the 1099 documents, but the testimony is there. The other thing to keep in mind, though, and I'll admit this candidly, even if this is not, this is just, I think, a truthful statement. Ultimately, as I read the classification cases, part of the point of the classification test is that formal distinctions like did they get a 1099 or a W-2, does their agreement say independent contractor or is it an employment agreement, those things are not of paramount importance under the test. The test is meant to sort of cut through the legal formalities to drive at the underlying economic reality of the workers' conditions and to sort of properly classify whether these are free agents in business for themselves or whether they are working in a manner that renders them dependent on the particular entity that is alleged to have been their employer. And that underlying economic reality test, and we've outlined, I think, at length in our briefs why we think, as a practical matter, the record here is overwhelmingly shows that these people were free agents. And to the extent the court sort of reflects on it in a manner that sort of factors in or accounts for the different factors, one of the ways to think about it, one of the ways I've thought about it as we've worked on this case, is just imagining the range of decisions that any of these nurses testified that they made during any given period, a quarter or 6 months or a year, and it was...
Can I stop you there?
Sure.
One of the things that stood out to me was the district court finding that nurses do not engage in independent judgment. And when admittedly, some of this is reading the record and some of it is just like general awareness of what work nurses do and what this court said in cases like celiac. I found that to be remarkable, that the suggestion that a nurse engages in no independent or exercises no independent judgment.
Sure.
And it's fair if an individual exercised no independent judgment, that would be really good evidence that they're an employee, right? But it seemed like to me that was the central move that the district court made. And so can you help me? I mean, it sort of belies sort of reality to me in how nurses operate and the importance of nurses in providing health care and the often quite independent judgment they're making in a given moment in time in a hospital or in any kind of care facility. But can you point me where I ought to look? I mean, I looked at the citations that the district court gave. None of them seem to support that view that these nurses exercise no independent judgment. Can you help me see where I would find the contrary view? I mean, I have some examples,
Sure.
but if you have other examples, I'd appreciate hearing them.
Certainly. So, and I think Your Honor is homing in on an important point, and the finding of fact that I believe Your Honor is referencing is either 43 or 44 in the number of findings of fact. It's one of the ones we've challenged explicitly in the briefing. And I think the first...
There are a lot of findings of fact.
There are a lot of findings of fact.
And there are several points that are important. It's important that you had a non-compete provision in there.
I think it's equally important.
It's really important you had a non-compete provision in there.
We should, and I would like to
It's
address...
really important that you call them employees in the contracts.
Those, I'd like to...
You got findings that go both ways.
Yeah, and I'd like to pivot
You've got points that go both ways. and you had a 7-day trial.
If I could, Your,
This is not like trying to decide this stuff on the papers or anything. He heard you out.
if I could, Your Honor, I'd like to pivot to address the points you raised about the formal
It's sort of
documents after
those
answering Judge
findings of
Richardson's
fact and
question.
conclusions of law after a bench trial are I always viewed as like verdict. You put verdict on top of them, because he heard you out.
Certainly, there was
What
a
do you do-
trial.
What do you do when you're reviewing a verdict? That's
Certainly, there was.
where we are here.
Sure, there was a trial, so if I can address the three things that are now pending kind of in order. The finding that Your Honor asks about, I think it's important to not do what the district court and what the government has done, which is conflate the second factor of the test, which is managerial choice and discretion and decision-making about that could tie to profit and loss versus skill, right? The district court sort of blends them, and it's not clear in that finding which factor the district court is referencing. The notion that nurses don't exercise choice or discretion in relation to the skill in providing medical care, I think makes no sense for the reasons Your Honor observes. And we cite in our opening brief, and I can get you when I stand back up the exact site, but we quote one of the nurses who describes the nature of the work they're doing with dealing with gastrointestinal tubes, tracheotomy tubes, dialysis ports, understanding the values of medicine, the value of different lab readings in medicine and stuff like that. They give needles, obviously. All of that clearly involves skill, right, which is the fifth factor under the test. In terms of the discretionary decision-making as it relates to their income-generating capacity, which is the second element of the test, I think on pages 29 and 30 of the brief, we walked through just a sampling from amongst the 20 witnesses of all of the different choices and all of the different dynamics they had to navigate in their role as free agents that shaped their opportunities for profit and loss at any given point in time. So I think regardless of whether you look at it as an economic question or whether it's a question tied to the actual literal provision of medical care, there is skill, there is managerial skill, and there is choice and risk involved on both of those elements.
Can you address Judge King's
Yes.
concerns?
So both of the points Your Honor raises, I think, are why I emphasize that it is meant to be a practical test. On the non-compete in particular, the case law, I think, is crystal clear that
Right, that's what I'm trying to point out. We're on the same page in that.
the case
We're
law
on
is
the same page in that, and Judge Jackson looked at both sides. And did you all ask for a jury trial or anything?
we were not trial counsel, but I don't think there was a jury trial.
You didn't
sought.
try the case. I assumed you tried
No.
the case. But, all right, but I don't know whether you had a right to a jury trial or not, but it wasn't a jury trial, but the judge heard it for 7 days.
But Your Honor,
And then he wrote the findings, the facts, and conclusions of law that the rules require. And how do we look at that?
yeah, and the answer is that number one, we think he misapplied the burden of proof. But even if he applied it correctly,
And even if it's a close call, juries make close calls.
Sure.
And trial judges make close calls when they sit as bench judges.
So I
When
want to
they're trying
address.
make a bench case.
I want to address Your Honor's question about the non-competes. Ultimately, the case law, I think, is very clear that what matters is the underlying factual economic reality, and that is where his finding on
And
that.
that's that six-element test that you.
Sure,
Right.
and the finding on the non-compete issue, the finding that the nurses were prohibited from seeking opportunities elsewhere is just flat wrong. 17
They
of
had
the
a
nurses.
non-compete, you had a non-compete clause in the contract.
That's correct.
And you'd say, we didn't control them.
But
You have to agree to not compete, to go to work for somebody that they're working for,
But the
that they're
question-
signed to.
Your Honor, the question under the test
They
is
have a
the.
non-compete clause.
The question under the test, though, Your Honor, the agreement also says that they were independent contractors and they got 1099s, but that doesn't mean that we win, right? What matters is what actually happened. 17 of the nurses were asked this exact question and testified at length. 14 of them were crystal clear that they routinely shopped for opportunities on a rolling basis all over the place with full knowledge on the part of Steadfast and the other people they were working with no repercussions. The only witnesses who testified about feeling restricted by that clause were three witnesses in circa 2017 before Steadfast had received
And you
legal
bought them
counsel.
insurance. And you provided them with insurance, did you?
Not malpractice insurance, and in fact,
No, not malpractice. I mean, the nurses, did they have health insurance? And workers' comp, you had workers' comp on them?
Steadfast did not provide health insurance. There was a workers' comp policy that Steadfast held, but it's not clear, I think, in the record, the scope of that and how it relates to the nurses versus the employees who are the W-2s at Steadfast office. But I think the point, Your Honor, is that the question of what the documents say, right, cuts both ways, because it's a contractor agreement. It's not an employment agreement. There's 1099s, not W-2s, but it does have a clause that you're right. If my client had a time machine, I'm sure they would not have put that clause in there. But the test...
And the agreement that they signed said employment agreement.
No, I don't think that's true. In fact, the agreement that the nurses signed with Steadfast, almost all of them say independent contractor agreement. Your Honor, I believe, is referencing that some of the facility contracts that Steadfast had with its upstream customers that were drafted by the hospitals. From the hospital standpoint, the hospital was sort of deeming these people to be employees of Steadfast. But again, the point of the test is that workers and whether they have a contracting status or whether they have an employment status shouldn't depend on the formal content of the documents that the workers don't control. It should be determined based on the economic reality of their experience. And that's where, Your Honor, we have, there were a lot of findings. A lot of them we think are not necessarily material under the 5-factor test, but the handful of findings that we've challenged, quite specifically in the brief, the record supports our challenge on these. And I wouldn't be here trying to climb that hill if we couldn't do it successfully. And the non-compete issue and the question of whether these nurses were free agents who sought opportunities from a range of sources, and then the implications that has for them being in business themselves versus being economically dependent is a critical factor in this case, and the record overwhelmingly supports our position on that. Two final points I'd like to make, at least in this initial engagement.
What that red light means?
Oh, I'm sorry.
Go ahead and answer. Go ahead, I'll give you a couple more minutes.
Just the two final points. One was that I guess the final point I'll make is that the medical infrastructure that was used to supervise nurses in all of the medical staffing cases from other jurisdictions that relied on so heavily by the government, none of that is present here, right? And when you have that, and you have things like the testimony of 14 of the 17 nurses about their independence, you start to have all of these things where if the record were different, we would obviously have a compelling case that these were employees. The problem that's, I think, what's troubling about the government's position here is each thing we subtract, each thing that's not present, it's never enough. There's no version of this arrangement, I think, that the government would accept. And that, I think, is very inconsistent with this court's prior precedents, both in Chau and in McFeely. And so we would submit that that should help shape the court's analysis. Thank you, Your Honor.
Thank you very much, sir. Ms. King?
May it please the court, Ann King for Applee, Acting Secretary of Labor. We urge this court to affirm the district court's determination after a multi-day trial and hearing numerous witnesses, and after making credibility determinations and fact findings which warrant clear error review, that the nurses here were Steadfast employees, that they were not in business for themselves, but they worked for Lisa Pitt's business, the owner of Steadfast.
I don't know the answer to this question, but can a nurse, say a registered nurse, can she just go out there and start her own nursing business under medical ethics or some other rule? I don't know the answer to that.
Your Honor, I don't know the answer from the ethics perspective either, but it strikes me that it would be very difficult for a nurse to independently establish their own business, because there would need to be some kind of framework or care setting.
Most nurses, there may be some exceptions to this, but most nurses require supervision of a doctor, right?
I believe that's correct.
There's certain nurses with certain, that operate separately, but by and large in the medical profession, they require supervision of a doctor. Now,
Yes,
that
Your
doesn't mean
Honor.
they need a doctor looking over their shoulder, right?
Correct, Your Honor. And actually, that's a good segue, Judge Richardson, to your question about whether the nurses exercised independent judgment and whether
Is the
that's relevant to the
Department of Labor's-
supervision.
Is the Department of Labor's view that nurses working in a hospital do not exercise independent judgment? I mean, do you agree with that conclusion? Does the Department of Labor agree that nurses do not exercise independent judgment?
It depends, Your Honor, and
So
the
you
reason
think- You
is,
think no. So you think many nurses in the United States do not exercise independent judgment when they are working in a hospital?
if by independent judgment, Your Honor, you mean that they,
No, I just want to understand, like, it's the finding that's made here, right?
yes,
Nurses do not exercise independent judgment, period, right? I mean, it says "and" here, but and the Department of Labor's view is that that is true, that nurses do not exercise independent judgment. I mean, that's a remarkable statement, if the Department of Labor believes that.
Your Honor, as I understand the district court's finding that you're
And
referring
I want to
to,
understand whether you agree with that finding or not.
I agree with it in the context of this case, and I can point you to
Because
some,
these nurses, so your view is these nurses did not exercise independent judgment when they were working in the hospital, right? When they're administering medications and treating wounds and taking notes and otherwise caring for patients. The Department of Labor's view is in doing those things, because that's the last part of the paragraph, that's what he's describing about judgment. The Department of Labor's view is that there was no independent judgment being made by nurses in doing that.
here, the
Can you
nurses,
start with yes or no, and then you can explain all you want to?
okay, yes, Your Honor, of course. So again, here, we agree
No,
with
I'm
the
sorry.
district court's finding. Yes, we agree with the finding
You
here.
agree that they exercise no independent judgment?
Your Honor, I'd like to point you to some testimony in the record that explains the nature of the nurses' qualifications and what they did. So for example, at JA 498, a nurse witness explains that the nurses who had different qualifications, such as certified nursing assistant or licensed practical nurse, they had already received, they had a standard of practice that they were already trained in. So a licensed practical nurse, for example, is already capable of nursing duties such as blood pressure measurements and vital signs. A certified nursing assistant is capable
Okay,
of,
so
is
help me
certified to be
understand
capable
that.
of.
When you come in and someone has injury to their head, right? And so the nurse is the first person that sees them. Do those requirements like dictate what is to happen, right? So the treating of wounds, right? There's no independent judgment being made by the nurse. When they come in and I have a wound to my head, the nurse exercises no judgment whatsoever. What is required, on 498, the standard of practice requires what to happen in that scenario?
Your Honor, I don't know the
Do they put a
details of
bandage on
what,
it?
perhaps,
Do they do
yes,
an
Your Honor.
MRI? Do they refer
Perhaps.
to neurology?
Perhaps, Your
Do they
Honor.
give them Advil? Those are all independent judgments though, right? I mean, this is the point. That nurse is plainly exercising independent judgment in deciding, do they need an MRI? Do I need to refer them to neurology? Can they wait in the emergency room longer or shorter period of time? How urgent is this? All of those are independent judgments.
Well, I think, Your Honor, the context here is important also. So these nurses were not permanent employees of these client facilities. They were filling shifts that the client facilities needed to fill in order to provide
But the
patient
district court
care.
found they were treating wounds, right? I just want to take one example.
That was one example,
right?
but there's
And to
also,
treat wounds has to require independent judgment. I mean, it's like remarkable to me that Department of Labor's view is that a nurse exercises no independent judgment when treating wounds.
I think the district court's finding has to be understood in terms of, is the nurse exercising the kind of independent judgment that's a hallmark of an independent contractor? And the answer here is no. At JA 151, a nurse testified that their role is to provide basic nursing care. JA 235, passing meds,
Okay, but
more
so
testimony
basic-
about providing
basic nursing
medication.
care Tell me what the basis is for finding that that does not involve independent judgment.
Again, Your Honor, it's the level of independent judgment that would be the hallmark of an independent contractor. Any role would involve some type of independent judgment. There's really, hard to imagine any employee role that would not involve some kind of independent judgment. For example, a restaurant server who is in charge of several tables is an employee, but maybe that server is exercising some judgment about which table am I going to visit first and which food will I expedite first. So I think that has to be understood in the context of the economic realities test. And the ultimate question, which is, are these nurses in business for themselves?
I'll stop with this, but, I mean, can you really read paragraph 43 that way? Because it says there's no independent judgment in performing, and then including but not limited to administering medications, treating wounds, taking notes, or otherwise caring for patients, right? That is, exercise no judgment in doing those things. Like, that's the only way to read that. That is, I'm with you. That's like crazy, right? I mean, of course there's independent judgment being explored. And the reason this is like super important, at least to me, is that the whole idea here is we're trying to determine who is the one that is controlling the manner of performing duties. And what the district court found is that the nurse has no judgment in performing in the manner in which it performs its duties. And I understand you want to interpret that more broadly, but I mean,
Yes.
that it exercises no control in determining how to treat wounds. And if that was true, then I totally get the district court's conclusion that they're employees, right? They're like widget makers, right? They're literally just putting the next piece on the thing, right? But that is like plainly not what they're doing, and not the way we ought to balance. And maybe if you had the proper balance, you might still get to the result that you like. But it seems really odd if we're trying to determine who has the balance of control here, if we do so by setting the scale up and saying that the nurse themselves has no independent judgment in the manner in which they perform their duties. Well, then it's no surprise that that zero is outweighed by anything else on the other side.
Your Honor, a few responses. Again, I do think that it's appropriate to read it more broadly. Is this the type of independent judgment that's a hallmark of an independent contractor? I also just wanted to respond to your point about the Silasek decision, which you mentioned earlier. That is a Title VII decision, and so it does not apply the economic realities test. There's some differences there also because the worker was a doctor rather than a nurse,
So the Department of Labor views like the judgment of doctors and nurses as being totally distinct, that nurses are like assembly line workers, where
No, Your
doctors
Honor.
are fully independent individuals who are making judgments.
No, Your Honor, not totally distinct, but I do think that's a relevant point here. And just to respond to something else, Judge Richardson, is you had mentioned that the manner of work is important, and it's true that this court in McFeely has explained that the supervision over the manner of work is relevant to the control factor. But that has to be understood in the context of the broader economic realities test and the focus of that test, which is to determine, are the workers economically dependent on the company, or are they in business for themselves? And so factors such as the model of pay, how the company controls scheduling, and also whether the company imposes any work rules on the workers are all relevant to the company's control over the manner of work performed. And here we have a model.
Are you arguing, I just want to make sure I understand.
Yes, Your Honor.
So McFeely refers to the manner that the work is actually performed, the skill of the work. Are you saying that that's wrong?
No.
Or just that it is supplemented by other things too?
Your Honor, I interpret that phrase in McFeely through the lens of the economic realities test, because that's
this is the same
the
thing you're trying
ultimate.
to do with the district courts. You're like, yeah, don't read the words, right? Don't read the words of the finding, don't read the words of McFeely, like, let's read it to be the opposite.
I don't think it's the opposite, Your Honor. What again, the focus of the test is, are these workers in business for themselves, or do they work for the company's business? And so any analysis applied under the test can be viewed through that lens. So I don't think that's changing the character of those words. And here the pay scheme is highly relevant, highly probative of control, because Steadfast controlled the rate that the nurses were paid. The nurses did not have the ability to negotiate. It was a take it or leave it rate. Steadfast provided the shifts and had control over scheduling in that respect. We acknowledge that the nurses ostensibly had the ability to accept and decline shifts, but there's ample evidence that they were disciplined when they declined shifts or berated by the owner of Steadfast, Lisa Pitts. That model where the company sets the pay rate, offers shifts to a worker that's on their list or their registry, and then is responsible for paying the worker, that's common in many of these cases that involve healthcare placement. It's also was the model that was present in the Sixth Circuit off-duty police case, which noted that there was an ostensible policy that the workers could decline shifts, but in practice there was discipline imposed for declining shifts. And it's also the model for a typical temporary employment agency, which is basically what Steadfast is. And it's quite typical in the temporary employment agency context for the agency to send a worker to the placement location and to not have any day-to-day supervision over the worker during their daily tasks. And then courts have acknowledged that that doesn't undermine the existence of an employment agency. And you can look at the Bay State case out of the First Circuit, and Superior Care out of the Second Circuit are really helpful on that point. Just to address another point here, Steadfast mentioned that that the nurses invested in their licenses, which they were required to have for their positions. And I believe that Steadfast was suggesting that the nurse investments in the licenses was evidence of an opportunity for profit and loss. But this court in Schultz, faced with a similar argument, said that an investment in a required license had little probative value on the opportunity for profit and loss prong. And turning to other precedents from this court that are on point, or that shed light on this case. Now, we're not aware of, there's not a Fourth Circuit case that involves a healthcare placement agency like Steadfast, although we cite some from other courts, including the Second Circuit. But a few factors that are helpful from this court's precedents on the economic realities tests. Several decisions from this court, including McFeely and the Mid-Atlantic installation decision, have noted that a worker's inability to negotiate pay tends to indicate employee status. And there's very strong evidence of that here. Here, the model was that Steadfast negotiated contracts with its client facilities where it placed the nurses, and it would set on a certain rate for the hours that the nurses would work. But then when Steadfast set a rate for the nurses, it wasn't that same amount. They took a portion based on their own business judgment. Sometimes the owner of Steadfast would offer a bump, a little incentive if it was a difficult to fill shift. But as Schultz explained, the workers sometimes received cash bonuses for certain shifts, but the court there said that did not show evidence of the exercise of managerial skills. Also relevant in McFeely is the imposition of workplace rules. And here, even though Steadfast wasn't engaged in day-to-day supervision of the nurses, it did conduct a type of supervision by issuing directives to the nurses about their conduct in the workplace. And although we acknowledge that, of course, independent contractors might also be subject to workplace rules, the tone of these directives is really not the type of tone that you would expect a business to use with an equal. They really have the tone of a boss talking to a subordinate. They say it in all caps and with exclamation points, "Be on time, no sleeping in the residence room, humility goes a long way." And those are at JA 1849 to 51. And finally, I do want to just revisit one more thing from McFeely. There, as this court noted, the company controlled the stream of clientele, and that was the same here. The Steadfast had relationships with its client facilities, and it barred the nurses from having discussions with the client facilities about rates or about shifts. And it also had a buyout clause in its contracts with the client facilities, which in conjunction with the non-compete provisions in its contract with the nurses, those together were another form for Steadfast to exercise control.
You take the position, so the non-compete says that you may not, you basically can't compete with their competitors. I don't read that as covering hospitals. I mean, I understand it would cover like another medical staffing company. That may have relevance or not, right? But why would I understand the language of the non-compete to cover, pulling a shift with a hospital outside of Steadfast's, purview?
Well, Your Honor, the language of the non-compete provision is very broad. It bars the nurses from working in any capacity whatsoever, directly or indirectly, in any business or undertaking which competes with Steadfast's business of placing nurses. But I think
Which competes, right? So,
yes.
So nobody would think that a hospital, which has demand for nurses, is competing with a supplier for nurses, right? That's not the way whatever we want to think about economic realities, and I know you think nurses do know independent work, that's fine, but we can't think that those are competitors, right? The supplier and the buyer are not competitors.
Well,
Or does the Department of Labor think that?
It's quite a broad, I actually have, I think, what's even better evidence that at least Steadfast thought it might
No, I don't
encompass that.
understand the language. Is
Yes.
the Department of Labor's position that a staffing company competes with the user of the labor? They are competitors.
I think it would, I'm sorry to not give a yes or no answer. I think it really has to depend. And here, Lisa Pitts told a nurse that she would be the nurse would be civilly liable if she went to work for a client facility. And so even if a court analyzing that non-compete provision would say the healthcare placement a site is not a competitor, Lisa Pitts claimed to at least one nurse that she could hold her liable.
But we have no evidence that she actually sued her or that there was any liability.
Yes, that's true. There's
Hospitals hire a lot of nurses.
Pardon me?
Hospitals hire a lot of nurses.
That's true, Your Honor, that they would likely have an HR.
Under the non-complete clause, none of these nurses could go to work for a hospital, for the hospital that they were working for.
That they were working for.
That they were serving for medical staffing.
Yes, and that was governed by the buyout clauses, which,
They couldn't do that.
yeah, yes, Your Honor.
They understood they couldn't do that. Neither of you have talked about the damages.
Yes, Your Honor, I'm happy to talk about that.
I know you got a red light, but
Yes, with leave, I'm
interested.
happy to address any questions.
Most of that comes from failure to pay overtime.
Yes, so
What do you call
The liquidated
The liquidated
damages,
Put those aside.
yes.
Most of the real damages comes from the failure to pay overtime.
They are equivalent here. Well, I think there was some
Well, the
reduction in liquidated damages.
That amount depends on what the.
Correct, yes, that's
All right,
correct.
But that they were calculated based on records
Correct.
from medical staffing.
Yes, Your Honor.
So you depended on those records. Are you all, and you were confident or that were accepted that those were accurate?
Your Honor, so there's a mechanism for ensuring that the calculations of that type are accurate under the Anderson versus Mount Clemens case, which we
I guess you need
cite.
to be able to rely on them because they're using them to pay
Yes,
IRS too.
So-
But there was some evidence that in one situation, somebody worked 168 hours in 1 week or something.
well, Your Honor, I think
So
that
they-
Steadfast misrepresented that in their brief, because what happened was that the records that they provided, which were overlapping and our investigator had to reconcile, showed that some workers worked more than 168 hours, and then the investigator realized that that's not possible, and so engaged in a practice of reducing those hours based on evidence that many workers would often work over 100 hours per week and worked double shifts or even longer than double shifts. So taking that into account, and there is a mechanism under Anderson versus Mount Clemens where the department uses records from the company to calculate back wages, and then the company has an opportunity to review. And here, the district court invited Steadfast to review those calculations numerous times. We first provided an initial calculation at the investigation stage, and yet Steadfast did not object to them and did not present evidence at trial that contradicted those calculations, and only raised an objection after trial. So that
Those were raised on appeal without being preserved.
It was raised in the district court, but as the district court determined, they had waived that argument, but also they were not entitled to any review, any relief under various federal rules of civil
So they were
procedure.
preserved.
I believe so, yes, Your Honor.
All right. And you're confident they're correct? The government is?
Your Honor, there may be some errors. That is often the nature of such calculations. And again, there's the Mount Clemens framework for giving the opportunity to correct them. And also, Mount Clemens has explained that if there are errors that stem from problems with the records that were provided as the basis of the calculation, then that's not a reason to set aside the back pay calculations, the back wages
But it involves
calculations.
a lot of money.
Well, it was a lot of overtime, as I said.
That overtime would go to pay the nurses' back pay?
Correct, yes. So, and as were the liquidated
Not something that
damages.
goes into the Labor Secretary's pocket?
No, not here, because the liquidated damages are also go to the nurses. And here, as I
The
said,
liquidated damages go to the nurses too?
yes.
Okay.
So, and as I said, some nurses worked over 100 hours a week, and since overtime is above 40 hours a week, you can imagine that would be
The overtime
a lot of
is
overtime.
Time and a half
Correct.
under the Fair Labor Standards?
Yes, that's correct, Your Honor.
Okay.
If no further questions, we urge this, any further questions? If no further questions, we urge this court to affirm the district court's ruling.
Thank you very much, Ms. King. Mr. Pafford?
Thank you, Your Honor. Just 3 points I'd like to address. First, on the merits of the classification issue, if the court concludes that the non-compete and the operation of that matters to the outcome of the classification analysis, then on this record, I don't think you can possibly have the same result for the nurses 2017 and earlier than 2018 and after. Because the testimony in 2017 from the 3 nurses asked was that they did in some way feel constrained by that, right? And we feel it's outweighed by other factors, but if the court concludes otherwise, That says something about the legitimacy of the government's claims 2017 and earlier. But you can't get to that result and then look at the uniform testimony from 2018 onwards, where every single nurse from 2018 onwards was asked about it, indicated that they did not feel constrained and they routinely sought a wide range of opportunities to maximize their income, and they used their managerial skill to navigate those choices. And it's not a coincidence that there might have been a shift in the economic reality at that point, because it was in 2018 that Steadfast consulted an experienced Virginia labor attorney and got advice to the effect of your model overall is good, but you ought not try to enforce this non-compete provision. So it would be, I think, irrational and very unfair if the non-compete is the outcome determining factor to have the same result for 2017 and earlier versus 2018 and after. Second point I want to make just in passing on the pay issue is that the model that is closest to the economic and structural model that Steadfast used here is the model.
What do you mean by the pay issue?
I'm going to get to the third issue, Your Honor, the damages issue, Your Honor. I'm talking about the manner of pay and the question of negotiation, et cetera. And the point I was just going to make briefly was that by far, of all the cases cited in both briefs, the one model that's closest to the model we have here within the Fourth Circuit is the Chow model for the brokerage case, where MAT sat as sort of in a brokering role in between the cable companies, which are in the role of the hospitals in our case, and the cable installers, which are, in the role of the nurses here. And so if you look, and we outlined in the briefs the way in which the structure of how this was set up and how the payment was handled was the same here as it was in MAT, and we think that that is a strong element in favor of the legitimacy of Steadfast classification. Final point is I want to speak, Judge King, to your question about the damages to clarify our position on that.
I just wanted to raise it, make sure it was.
And I think it's important.
I had an opportunity to discuss it.
And I appreciate Your Honor raising it, and so I do want to speak to it.
Go right ahead.
As you know, our firm was not involved in the trial, and so this was stuff that was discovered after trial, but prior to any kind of final judgment. And this court well knows the history of this case, and that there was not a final judgment until maybe December of last year. And so we raised it well in advance of that. And the 168 hours issue was, I want to make clear why that matters. That was just a red flag. That's what caused us to look. Because what happened is...
It was a red flag of a mistake?
Yes, because what happened...
Because 168 hours is the number of hours in a week.
Yes, exactly. Okay. And so the red flag was that in the investigator Mozuera for the DOL, who had compiled this back pay table, was deposed. And he was deposed, again, not by us, but before trial, and we had his transcript. And in the transcript, he doesn't mention anything about, oh, by the way I analyze your records, something's crazy here, because I see people working more than 168 hours in a week, which is obviously impossible. It was not until trial, in his testimony, that he revealed that fact. And then we, of course, after trial, having the benefit of that, say, that's strange, that doesn't make sense. So we go back and look. And again, there's no final judgment, so we have the right to seek post-trial relief to correct errors or manifest injustice under the various rules. What we discover is that out of the 10,000-page back pay table that's in Volume 5 of the record, literally thousands of entries are wrong, and they're not wrong in a complicated or tricky way. It's that our payroll records show a nurse working, let's say, 50 hours in a week. But the column for hours worked in the DOL table will just cleanly double it. If it says 50, it says 100. If it says 45, it says 90, and so on. And then in others, it's a little more subtle, because if let's say our records show them working 45 hours in a week, then the DOL table will show a random number, like 78. It'll be an increase, but it won't be a clean doubling. But the point is, we went through all of this, and we said you can't ask our client to pay not only once, but twice because of liquidated damages, right? Everything we're exposed to for back pay gets doubled because of liquidated damages. We can't pay twice for hours that were not even worked once. It's grotesquely unjust, and we provided to the DOL a breakdown in zip files, and this is talked about in our briefs, and we cite to where we flagged this for the district court in the record. We took their 10,000-page table, broke the whole thing down into massive zip files, and color-coded it. And the lines where there was no error, we coded in green, and there were a lot of them that were okay. But then the lines where we found these errors, we coded them and showed where the error was. And for 3 years, The trial team at DOL wouldn't even meet and confer with us on this, no matter how many times we asked, let alone show any interest in correcting it. So that, Your Honor, is our perspective on the damages issue, and I do appreciate the chance to address it.
Did you ask for, if you lose on the liability, did you ask for a remand on damages?
Yes. In fact, in our opening brief, if you read the section on damages, we say quite clearly the relief we're asking for. If the court upheld the classification analysis, or even if it upholds it in part for 2017 and earlier and strikes it down for the later, any part of the damages the court upholds, we ask to...
And there were damages were calculated in 3 segments. I didn't call them segments, but I remember there was class 1, class 2, class 3.
That was just based on time, Your Honor, because the initial lawsuit was filed in 2018, and so the first tranche was for the people who had worked prior to then.
But the
and then as they...
liquidated damages didn't apply to all 3. It applied to the first 2, and then it didn't award liquidated damages on the third group.
The only...
Because of the so-called good faith defense.
Well, not because of the good faith defense, I do want to clarify this. Everything that was tried by DOL, all of the stuff introduced at trial and all of the back pay that was found, they got liquidated damages on all of that because the court rejected the good faith defense that offered at trial. What Your Honor is asking about is post-trial when all of this was done and over and we were bound by the injunction, right? And we were paying the people under the district court's injunction as W-2s or not, I don't know if it's W-2s, we were paying them overtime under the FLSA. There was an allegation in 2022 or 2023 that we were not listening to the trial court's ruling, right? Like while the case was up on appeal. And we did go back, do an audit. There was a small number, maybe 250,000 that we had to correct in terms of back pay out of a multi-million-dollar payroll.
They recalculated that.
Yeah, that amount, Judge Shaxson said, listen, you're liable for liquidated damages for everything up through the end of the trial and up through my decision, but in terms of post-trial compliance while the case was on appeal the first time, maybe you messed some stuff up, but overall you were doing pretty well, so I'm not going to hit you with liquidated damages or some other penalty for that small amount of $250,000. But again, the overall back pay in their table, I think, is roughly 4.5 or 4.6 million, and Judge Jackson indeed doubled that to get to a judgment that's north of 9 million. And again,
that's the statutory liquidated damages.
Sure, but there's a statutory defense, which is the good faith defense, which is what we've argued in our briefs.
And you rejected the good faith defense.
That's correct.
Yeah.
Which we think was wrong for all the reasons we've outlined.
And you're contesting that.
Of course.
I understand.
Okay.
I wanted to cover that for you. I'll get that out of here.
Yeah, we are absolutely contesting that. We're contesting.
Yeah, I know you are.
We're contesting every element of what happened below. But I appreciate Your Honor's time, and if there's no further questions.
Thank you very much, sir.
Thank you.
And the case will be submitted, and we'll come down and greet counsel and take a brief break.
Just all for the Fourth Circuit.
Be seated. In our final case, number 23-2013, Sigley versus N.D. Fairmont. Mr. Glazer.
Good morning, Your Honor. May it please this honorable court, Justices Richardson, King, Floyd, counsel, Mr. Gray. It's my honor to represent my client. My name is Hoyt Glazer, and we are on appeal here on some pretty simple issues, although I do think they pose interesting questions. The main issue is whether the district court committed clear reversible legal error in ruling that the defendant, the appellee here, did not discriminate against my client, Mr. Sigley, when it fired him for not previously disclosing his medical information on a health questionnaire. Now, what's interesting about this case, first, is that there's really no dispute on the facts. We've stipulated to a lot of the facts, so there's not a factual dispute here that you have to decide. Rather, it's the application of the law. And I'll cut to the chase here, Your Honors. In this case, the district court said, look, this is a matter of a standalone claim under the ADA for breach of confidentiality, and said there was no breach of confidentiality, and therefore there's no ADA claim. And I submit to you that's clearly wrong, because this was a standard ADA claim. In fact, we have alleged that there was an improper...
Does the ADA protect employee for lying to the prospective employer?
Yes, Your Honor, it does under these circumstances, if I may elaborate. The ADA says that you cannot have an improper medical inquiry that involves anything that would lead to information about a potential disability, potential or otherwise. Here's what is interesting about the ADA. That medical inquiry provision protects every employee, not just disabled employees, but also employees that are not disabled. And that ties into the reasonable accommodation aspect of this claim. My client didn't disclose. He lied. And that's not a doubt here. And there are reasons for that, but...
When did you ask for an accommodation? But your client.
Okay. My position is that he was doing the job, and he didn't...
When did you ask for an accommodation?
I do not believe that that issue was... I don't believe he specifically asked for an accommodation in the sense of he was looking to be accommodated, if that makes sense. We didn't really develop evidence on that. It's the employer's position that he didn't ask for an accommodation. It's my position that if the employer was going to do anything here, it had really three options. The first option is, do you need any help, Mr. Sigley? Let's see what we can do. And at that point...
So your view is that the ADA requires the employer to determine whether accommodation is warranted even when it's not requested? So they sort of are a roving band of accommodation providers? I need to go like find my law clerks and walk through on a daily or quarterly basis, and are you good? Is everything good? Do you need like, you know, a backrest, or do you need a different kind of pen, or?
My answer to that is they're not a roving band. They're not required to read minds, Your Honor, and they're not required to do that. What they are required to do is they are required not to discriminate. And what that means is what they can't do here is,
Well, how does accommodation get in here? How can you get an accommodation issue in here if you didn't ask for it, but you were obliged to? Did the judge had some roving writ to raise accommodation for you? Or
No.
we have some roving writ
No, Your Honor.
to let you raise it on appeal when you didn't raise, you actually first raised it, I think, in your summary judgment request.
Correct.
You didn't raise it in your complaint. You didn't raise it with the employer. You raised it in your summary judgment request after discovery. As I recall, that's on this record, that's what it reflects about accommodation. Is that fair? If it's not, you correct me.
We raised discrimination based on perceived as disability.
I'm talking about the accommodation issue
Okay.
or claim.
For the purposes of this appeal and for the purposes of this claim, I would say that accommodation is not an issue. But if the court believes that we didn't raise it, I'm not going to argue against that because I don't think it's dispositive of this appeal or what the
So
judge
when you-
decided.
When you say in your brief that appellee violated its mandatory duty of reasonable accommodation under the ADA, we can like delete that section of the brief?
That section applies to the argument I'm making. What I mean is this. When he says, I have a back injury, if he says he has a back injury, the question is really this: is that sufficient to say, I need an accommodation? Now, that was not developed on the evidence. That was not developed below. It's my position that it didn't need to be developed because medical inquiries are prohibited. Medical inquiries, that's the only thing that this court needs to answer and that the court below did not address. The medical inquiry itself is violative of his right, and it doesn't matter whether he requested accommodation. I would tell this court that the reasonable accommodation issue, honestly, I would say he didn't ask for a reasonable accommodation in the sense of we developed it and
He
it's
didn't ask for it, he didn't sue for it. He didn't sue for it, he didn't ask for it. But you briefed it to our court that was a violation of the law, not to accommodate.
well, and the reason is
You used a big part of your brief to talk about it.
because it goes to part of the decision.
And even in the district court, you didn't sue, you didn't raise it in the complaint, you raised it in your summary judgment motion
Yes, Your Honor.
for the first time.
Because it has to do with the idea of the protections under the law, the stereotypes, and the perceptions.
As a matter of fact, your summary judgment motion raised two issues, neither of which were in your complaint.
Well, our complaint was for discrimination under the ADA. We have established that the reason they fired him was because they said he didn't disclose that he had this condition. And the question
I
is,
thought they fired him for lying.
they fired him for lying, but the point is, Congress and the ADA does not prohibit someone from not divulging what they said he should have divulged on the application. That's the whole gist of
So
this.
you would have us say the ADA protects you for lying.
No, Your Honor, that's not what I'm saying at all.
You should lie to the prospective employee.
That's not what I'm saying. What I'm saying is,
Pretty hard.
I'm sorry?
That's a pretty difficult proposition to market.
Well, I'm not arguing that the point of this is that he should have been able to lie. The point of this is that ADA protects people from perceptions about what they can or can't do. Mr. Sigley did not disclose this. Now, here's what's very important, and I've argued this before, and I've argued this in the brief.
But is there a difference between not disclosing and outright lying?
I don't think there is.
Okay.
I mean, I'm not going to...
I know you want to say he didn't disclose, but you agree, he lied.
Absolutely, Your Honor. I'm not going to even argue that to this court. I mean, that's not...
Can I ask maybe a similar question to Judge King? If, this is hypothetical, right? So just take the ifs, right? So if I found that they were permitted to ask him the question and they were permitted to rely on his lie to fire him, right? And I know you argue against that, but if I found those two things contrary to your view, is that dispositive? So they could ask him and they could look at what he said in the form and say he's a liar. If I made those two determinations, is that dispositive? I understood the district court to say that would be dispositive of your discrimination claim. And I don't see you arguing to the contrary, but I want to make sure.
If the court were to find that he lied and that they could fine him for lying, and I do believe I addressed this, but if I didn't, let me make clear. It's all embedded in the condition. It's inextricably linked. In other words, if
In
he,
the condition? I don't understand.
well, when he says,
So start with yes or no.
Okay.
Right? If I find that they were permitted to ask him about his back, and that he lied about it, and that they were permitted to fire him for lying about his back on the form and in any other context. If I found those three things, and you challenge all of those, I totally understand your challenge. My question is, if I disagree with you on all 3 points, is that dispositive?
if he lied, you found that he lied,
Well, you admit he lied. So I got
absolutely,
it.
we're not even
Yep.
arguing on
Okay,
it.
he lied.
And that they fired him for lying, which I don't think is an issue here either. Is that dispositive? And my argument would be, under the ADA, no, because the question is, was the medical, in other words, could they ask him, could they ask him about his back injuries? They checked to see whether he told the truth. My position is, they could have referred him out for an exam. They could have asked him more questions about his back injury. They could have done that. And I realize the accommodation issue, and that's how it plays into the argument. It's for an argument that I'm raising this. In other words, if they believe that he was having an issue, the answer isn't, was he lying? That's not dispositive, in my opinion. The dispositive is whether they fired him based on his disability or perception of his disability. In other words, they believed that he lied, he violated, we could fire you because you lied. You had back injuries, and you didn't tell the truth about that. But the point is...
Did they tell him directly, we're firing you because you lied? That's what they told him.
That's what they told him.
And that's what this record says.
Correct, and that's what my client understood. His deposition was not taken, but that's my understanding, is they said, you know, you falsified records, you signed all these different places where you acknowledged that's our policy, you said that you understood that, you didn't disclose, we're firing you, that's it.
So you think we should go beyond that and see through it?
Absolutely, because here's the thing. The result may be something that, I don't use the word abhorrent, but it may be an unpleasant result here. In other words, as you said earlier, Your Honor, is it right that we allow somebody that lied and they fired him for lying, and is that what the ADA really allows? And I would submit, and I have argued this, that Congress has not said, you know, you can fire somebody if they don't disclose on a health questionnaire. They haven't said that. And the Blanco case says that too. That's up to Congress. They didn't have an exception that if you lie, you lose the protections under the medical inquiry protection. Medical inquiry protects everybody, disabled or not. It protects us all. Now, the fact of the matter is, if they had gone about this a little more carefully, then I don't think we'd be here. If they said, okay, Mr. Sigley, we're going to give you a physical, you're going to be referred out, we want to see what you can do. But
What would they, I don't understand that argument, right? So why would they have referred him out? They fired him because he's a liar, not because of any other reason. They don't need to send him to another doctor. Like a doctor, I mean, they might want to send him to an FBI agent who runs a polygraph, right? But sending him to a doctor doesn't do anything because they're not firing him for that. They're firing him because he lied. Why would they send him? I just don't understand the argument. I'm trying to understand it,
okay,
but I don't understand the
very
argument.
simply, it's my position that the employer did not recognize that they could not do what they did. And I understand this court has an issue with him lying, but the solution
They did
is...
not recognize that they couldn't do what they did. So can you fill in some of those?
Absolutely.
Those pronouns, right? So
Yes, sir.
they couldn't fire him for lying?
Not under these circumstances.
And just to put a point on it for me, why?
Because,
Did you just list your arguments for why that is?
yes, when they ask him about, did you disclose your medical condition on your health questionnaire, that is a prohibited medical inquiry under the ADA.
Okay, they couldn't ask. All right,
couldn't
so
ask.
I understand that. What's the next argument?
But when they pursued it and they determined whether he did, they're not determining anything about what he can or can't do. They're just trying to figure out if he's honest or not.
And they're not allowed to determine whether he's a liar. Okay, what's the third argument?
And that's it. I mean, they can't do that, Your Honor. I mean, the ADA...
So in other words, your argument is really, when we think about McDonnell Douglas, your argument is a step 2 argument. That they cannot give a legitimate reason for firing him.
If I may?
Yeah.
I think their reason for firing him was not legitimate per se because the ADA says you can't have a prohibit. In other words, they're basically saying, I mean, this is the extent, is that he basically waived his right to his ADA protections when he says, I understand you can fire me for not telling the truth. That's essentially the import of what they're saying, Your Honor. I mean, again, and I know my time's up, so I'll stop if you want.
Finish your answer.
Yeah, so again, I think it may be, yes, he lied, but at the end of the day, the ADA doesn't prohibit what he did, but it does prohibit the employer from firing him for just lying under these circumstances. Thank you.
You got some rebuttal time.
Yes, sir.
We'll see what Mr. Gray has to say about this.
Good morning, Your Honors. My name is Kelby Thomas Gray from Dinsmore and Shoal in Charleston, West Virginia. It's an honor and privilege to be here today, and I represent ND Fairmont in this appeal. Wanted to start, I had an argument, but I kind of want to address some of the questions you all asked earlier. The first one was asked by you, Judge King, does the ADA protect someone from lying? And the answer to that is no. The Fourth Circuit, this court, has held that misconduct, even misconduct related to a disability, is not itself a disability and may be grounds for termination. That was in Neal versus Eastern Carolina University. The Fourth Circuit decided that back in 2022. In 1999, the Fourth Circuit decided Jones versus American Postal Workers Union, and the Fourth Circuit determined that the ADA is not violated when an employer discharges an individual based upon the employee's misconduct, even if the misconduct could be related to a disability. And then in Hannah P. versus Coates, the Fourth Circuit stated the ADA does not require an employer to simply ignore an employee's blatant and persistent misconduct, even where that behavior is potentially tied to a medical condition. In that case, Your Honors, is Hannah P. versus Coates, decided by the Fourth Circuit in 2019. So that's to address your first question, Judge King. The second question was, when did he ask for an accommodation? He never did. He never asked for an accommodation.
Well, he briefed that, or made that request, raised it in the summary judgment motion.
That is correct, Your Honor.
And was there anything in the summary judgment motion that was raised in the complaint?
No, Your Honor. And in fact, if you look at page...
Was there ever a motion to amend the complaint?
No, Your Honor.
Well, how can he raise the issues in the summary judgment request that weren't sued for?
He can't. And even in his...
So, are you saying we should affirm the district court?
Yeah, I'm saying you should affirm the district court's
Well,
grant of summary judgment to ND Fairmont.
Is that the right request, or should we dismiss? If there's no match between if there's no match with the complaint?
I'm saying the Fourth Circuit, the court, I'm asking the court to affirm the district
I know
court's...
you're asking us to affirm it, I just wondered if that's what.
Maybe I'm not...
Proper request, or whether your proper request is to dismiss.
It could be, I mean...
Maybe that's what should have been your motion in the district court. Summary judgment request didn't match the complaint. He didn't move to amend the complaint.
No, he didn't, and I've had that...
Don't we have law that...
You can't do that. I have law, not Your Honor. I can't tell you the case, but I've had some other cases in federal courts in West Virginia where a plaintiff has tried to do that at the summary judgment stage. We filed the responses, and when in the summary judgment, the decision by the...
Amended by operation of law or anything by way of a mismatch when you have a motion for summary judgment, I don't think. That's what troubles me about this, whether any of the issues on appeal, whether they should be dismissed, or whether the court should be affirmed, or whether what we do with the appeal, maybe dismissals are alternative. But you wanted to affirm.
I would like the district court's decision granting summary judgment to ND Fairmont affirmed.
You filed the motion for summary judgment addressing the claim that was raised in the complaint.
Yes, Your Honor. And even in his appeal brief to this court on page 5, he states, Mr. Sigley filed a one-count ADA claim against the appellee asserting disability discrimination.
And so your view of the, and I know there are a bunch of these other arguments below and on appeal, accommodation and the like, but your view of those, they're not separate claims. They're arguments that your colleague is making. They might be irrelevant arguments, but they're simply arguments about a single discrimination claim. Okay.
Okay. And then I want to reiterate what he said there, Your Honor, that, Mr. Sigley admits, his counsel admits that ND Fairmont fired him for lying. Mr. Glazer mentioned that the ADA protects perception, and I would respond to that with the only thing that ND Fairmont perceived was that Mr. Sigley was dishonest. He mentions
Would this be different if there wasn't a voluntary? So I understand under Hannah P. This protection does not protect information shared voluntarily, right? This confidentiality provision. And here, he both admits that he lied, and then there's a record that shows that he lied. But if we didn't have that admission that he lied the first go-around, this disclosure and admission, would that have been a problem?
It may have been.
So if they then, without that admission, if they had just gone back to the original form?
If they had started making an inquiry, it may have been, Your Honor, but this was different in the case that he voluntarily disclosed his medical information and history to ND Fairmont.
Let me ask you this question. I'm not sure I quite understand what I'm asking anyway, but are applications and post-hire exams, are they governed by different ADA provisions?
Yes, Your Honor. There's different provisions for pre-employment, and then there's provisions for what I call the post-offer examinations or employee employment interest examinations.
So,
And then there's a different provision for.
so what he alleged was, I think he just alleged an improper medical inquiry. Is that sufficient to get to both of those issues?
I'm not sure if I understand the question. I think.
I'm not sure I'll ask it right.
Yeah, I think that he's under 12112D, it has a different provisions for medical examinations and when you can do those and at what time, okay? The first one regarding is pre-employment. I think he's focusing on the pre-employment portion of that statute. But what we're focusing on, and even what he briefed and what the district court focused on, was 12112D3 that talks about employment interest examinations. And it states this: a covered entity may require a medical examination after an offer of employment has been made to a job applicant and prior to the commencement of the employment duties of such applicant, and may condition an offer of employment on the results of such examination.
Well, just help me along, but you may be right, he's focusing on the first one, but suppose he's focusing on both of them. Does it make any difference in the outcome of this case? Both provisions.
Well, I would say, I don't think the first section regarding the pre-employment is at issue, Your Honor, just because he concedes, and there are stipulations in the record where he concedes that his application that he submitted for employment with ND Fairmont requested no medical information whatsoever, and it was lawful. So I don't think that first section applies. We didn't violate that. I don't think there's any dispute on that.
Can you help me understand, I think I know the answer to this, but why a sort of post-offer entrance exam is permitted? Is this a workers' comp issue? I mean, are we trying to develop a baseline? I mean, I guess what I'm trying to figure out, it seems like to me the reason that your client cares about him lying about his back injury is maybe significantly about workers' comp, right? It doesn't want to hire people who have pre-existing injuries and then have them come in and dishonestly claim that that injury resulted from their work.
I don't know, is your answer, what is the purpose of?
Yeah.
I don't know what the purpose of it is, Your Honor, but I know the ADA allows it, and it allows employees.
And there's nothing in the record as to what. I mean,
No.
maybe it's, and I get it's not totally relevant, but there's nothing in the record that tells us like why they care about the lying.
They conduct these employment examinations for all applicants, all new employees prior to the commencement of job
It's
duties.
a routine.
It's routine, Your Honor.
And the record indicates he was able to do his work.
He was. And we were talking about the voluntary disclosures, Judge Richardson. I would also point the court to another case that you all decided, Reynolds versus American National Red Cross. It was decided by this court back in 2012, and the court affirmed summary judgment in favor of the employer on the plaintiff's ADA confidentiality claim where the plaintiff voluntarily disclosed his medical information. And in this case, the medical information and the history relating to Mr. Sigley's back condition and treatments were voluntarily disclosed by Mr. Sigley. That's not in dispute.
Is your view that once he does that, that means the record itself, the employee entrance exam record itself, is no longer confidential because he's now disclosed that information?
That is correct, Your Honor, and that's what the Fourth Circuit has decided in some of these cases, dealing with the confidentiality provision of the ADA. Yes, and it allows the employer to inquire further. And I would also mention, Your Honors, that for almost 30 years that the EEOC has recognized the lawfulness of ND Fairmont's termination of Mr. Sigley's employment under these circumstances. I understand that the EEOC guidance is not controlling, but it is persuasive. They have a technical assistance manual that asks, what if an employee provides false information about his or her health, physical condition? And the EEOC answered, an employer may refuse to hire or may fire a person who knowingly provides a false answer to a lawful post-offer inquiry about his or her condition or worker compensation history. We've heard today there's no dispute he lied. We heard today when it was confirmed that he was told that he was fired because he lied. If he's trying to expand and say this should be governed by some kind of burden-shifting framework, well, that's gone too because we have a legitimate non-discriminatory reason for firing Mr. Sigley. His falsification, his lying. And we've heard today that they concede that, so therefore they're not even able to show pretext. So under all circumstances.
You raised, so I've not, in reading his briefs, I don't understand him to have made a pretext argument. Right,
No.
at step 3, you just brought it up. I don't understand any of his briefing below or here to say, even if they can fire him for lying and even if that's permitted to inquire and all of that, that we still think that they're just making that up. I don't understand there to be a separate pretext argument.
I don't either. I think I follow what you're saying.
You just brought it up. I want to make sure I was
Yeah,
understanding.
yeah. In his brief, I would mention, Your Honors, that Mr. Sigley cites to 3 out-of-circuit cases. I would highlight the fact that none of those cases deal with the issue here where the information at issue was voluntarily disclosed by the employee, and one of them actually dealt with a separate provision of the ADA confidentiality requirements for an examination at a different time period. I don't, unless Your Honors have any more questions.
See, you're not mandated to take all your time.
Yeah, yeah. I mean, I think this case is simple. I think this case is simple, Your Honor. He lied. It was a lawful It was a lawful post-offer examination. There's no dispute that that was lawful. There's no dispute that the questions he was asked in that was lawful. There's no dispute that he voluntarily disclosed his medical condition and history to ND Fairmont, and there is no dispute that he lied. There's also no dispute that ND Fairmont terminated him for lying. We heard today he wasn't fired because of a disability. We heard it today. Even from Mr. Sigley's counsel, he conceded he was fired because he lied. Thank you, Your Honors.
Thank you, Mr. Gray. Mr. Glazer?
I'll be brief. I understand the justices see it, and I don't want to belabor this issue. It's our position, it's been our position, that the reason they gave, we fired him because he lied, that is embedded. That is an improper medical inquiry. That's it. And the bottom line is, you can read through their briefs, you can read through my briefs. There's not a single case that I have found or that they have cited that specifically allows this to happen. Now, as far as the misconduct issue, I submit to you that Hennepin is not the same situation as this case. When you're talking about misconduct on the job, we think of traditional situations where people may show up intoxicated, there may be violence, they may be flouting rules. In this case, the misconduct is they said that he should have answered that question in the affirmative, and that was misconduct when he didn't. And our position is that when he's working there and they ask him if he disclosed, at that point, that is an improper medical inquiry. They just can't ask him that. And the reason is because the ADA protects everybody from unlawful stereotyping. In other words, if we think somebody has workers' compensation injuries, or we know, and we're afraid they're going to cause an accident at work, Congress has recognized you can't use that as a reason not to hire them, because that's a stereotype. Someone who's injured is going to pose a health hazard or a safety hazard. That's why we have the law. And in this case, Mr. Sigley, and I don't think they've argued otherwise, Mr. Sigley was doing his job. He'd been doing it well. There was not an issue with his job performance. Let's make that clear. This only came up, interestingly, because he told his employer, listen, I wasn't able to sleep well last night. I need some time off. Because he was, ironically, honest about his inability to work, he now finds himself here.
There is irony that he was honest. I agree with that. I'm
Yeah.
not sure it's in the direction you wanted to be.
I understand, right? I realized as I was saying that, I understood the irony within the irony. But I'll be brief. I submit to you that this may be a result that the court may not like. But under the law protects people from having their medical histories inquired to. It protects us all. And the bottom line is, at the end of the day is if there were any concerns, if there were any worries, there was a right way to do this and there was a wrong way. And the law allowed for them to do it the right way. So I will cede my further time. I appreciate the court's opportunity to let me argue. Thank you.
Thank you, sir.
Thank you.
We appreciate your...
Your Honors, I know that I had a couple minutes left. If you'd like me just to answer his first question about, I will. If not, that's okay.
You don't have any time left.
All right, thank you.
But we appreciate the services of both of you in this case, and it's nice to have you here. It's always good to have good West Virginia lawyers in the Fourth Circuit. And we will come down Great Council and adjourn court for the day and for the week. Signed, aye.
This honorable court stands adjourned, signed aye. God save the United States and this honorable court.
Good.